Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Maureen Brady, Associate Professor of Law at the University of Virginia School of Law. We will discuss her article, Property and Projection, which will be published by the Harvard Law Review. So welcome to the podcast, Molly.
Thanks so much, Brian. It's delightful to be on.
Well, the pleasure is all mine. As I was saying earlier, I'm a huge fan of your work, and I really loved the Meets and Bounds paper you published recently, and this new one about projection speaks especially dearly to my heart, because before going to law school, I was actually a projectionist at a at a repertory movie theater anthology film archive. So projections are near and dear to my heart. But I was wondering, for people who haven't had a chance to look at the paper yet, maybe you could start by just talking about what you mean by projections and sort of what's the nature of the kind of potential property invasion that you're talking about in this paper.
Yeah, sure. So I became interested in this project as it seemed to me over the last about 5 years, started seeing more news stories, particularly in big cities, about projections occurring without consent on the sides of buildings. And so some of these are government buildings, others are private buildings, and these are light projections. So putting a message or a video or a picture, a still image on the side of a building. And part of what I found interesting is that there were first a lot of questions about the legality of these projections. Like many people, when I first saw these, maybe many property professors, I first Googled sort of, is anyone looking at this? A lot of sort of discussion forums where projectors themselves were wondering, can I do this? There's mixed evidence on the always reputable online anonymous discussion boards that sometimes it seems lawyers participate in. But more strikingly, there were two cases decided where property owners had tried to stop projections on their buildings. In both cases, they involved unions projecting messages, in one case about bodily fluids on a bed, and in another about a restaurant's health code violations. So hopefully you're not eating dinner over there. But they were projecting on these sides of buildings, and after the owners tried to stop them under theories of trespass and nuisance and a couple other forms of claim, the courts basically said they were without relief. And this struck me as strange because when I teach property, I teach trespass and nuisance, and we talk about trespass as unconsented entries onto land, and we talk about nuisance as non-trespassory harm. And that sure sounds like it should cover the range of actionable harms to property. Sort of if it's not one, it's the other. And so that got me thinking about where this should fall, if it should be something, first of all, that projectors should be liable for under a property law framework. And second, where does it go as a trespass or a nuisance? And what does that reveal about property more broadly? So in the paper, I trace kind of the history of light projection related claims in trespass and nuisance, which proves to be pretty awesome and interesting history, beginning with what sounds like the most awesome late night croquet game ever in BC, where there's sort of wickets lit up by fire and it's disturbing a pregnant woman next door. They're smoking cigars. Again, it sounds pretty awesome, but not for the neighbor. And from that history, what you can deduce is that trespass doesn't cover light because it's intangible, and nuisance doesn't cover light because it doesn't tend to cause either economic harm to buildings or sensory harms to the occupants and users of buildings. And so I sort of talk about that history, and then I think about, should this be something that's protected by trespass and nuisance? And I kind of trace three different harms and interests associated with projections. So I talk about being intentionally targeted by projections and how some of the cases suggested that if intentionally projecting at a building ever happened, that should be actionable. And then I talk too about kind of the communicative uses of owners, where those are recognized across law, and then also what I call the presentation interests of owners. So the rights of owners to communicate with their thing, with the appearance of their thing. And all this put together, I say this is something that we should think of as part of the owner's property right, the right to communicate with and through your property. And it's something that I think nuisance can protect. But more broadly, I think it reveals some interesting things about the relationship of privacy and property, and also about kind of the evolution of trespass and nuisance as we think about it compared to other aspects of tort law more broadly.
Cool. So maybe just for listeners who haven't had a chance to read the paper itself, you could talk a little bit more specifically about some of the particular projection cases you discuss in the paper. Like what exactly happened and what were the, what were the reasons for the property owners to be objecting?
Yeah, so in the two cases in particular, so there have been a lot of examples of projections, and I could talk about some of those that are kind of fun and wild. But in the two cases, I'll just kind of summarize those. So there was the one in Las Vegas where, again, projectors affiliated with members of a union projected a restaurant's health code violations onto the side of the restaurant after I believe the restaurant wasn't using union labor in their construction project or maybe in the restaurant itself. And so as the court considered whether to make this a trespass or a nuisance, they said his trespass has always been about tangibles, so about physical things crossing boundaries. The most obvious example of a trespass is a person, right, walking across a boundary. But some other things have been considered trespass. Sometimes if you cause water to go onto property, some other sort of physical items. It's the intangibles, so like light and smoke, sometimes particulates like dust, and noise that traditionally courts have said cannot form the basis for trespass claims. Courts have suggested that those types of intangibles should be considered under a nuisance framework. And so after the Las Vegas court rejected the claim of the hotel owner that the light projectors should be liable in trespass, again, because it was intangible, they went to sort of talk about nuisance and said there were no allegations of economic harm. And so without allegations of economic harm, there couldn't be kind of a substantial harm forming the basis of a nuisance-like claim. There was a really interesting concurrence in that case by Justice Tao, who I think, like me, thought there's something wrong with this picture, that there's no liability here. And he sort of suggested that nuisance would be the proper place for considering claims against unconsented to projections, and set out kind of an initial framework thinking about maybe the communicative aspect of the text or message, about maybe the intensity of the projection, whether it was targeting, but sort of offered some tentative thoughts. And so I view him as kind of inspiring some of my thoughts here, although I think we disagree on some of the particulars. The other case I'll mention just really quickly because it's interesting is the Philadelphia case involving a union too, which projected actually a parody logo on the side of a hotel, again, in some sort of labor dispute. That case came out pretty much on the same reasoning, that it was intangible, so not a trespass, no economic harm because not a nuisance. But that case interestingly said that the value of speech is so important that when you weigh it against the minimal harm to the owner, that should particularly counsel against finding a nuisance. And so in both these cases, they've said that projections can't really form a basis for liability under either cause of action.
So one of the things I thought was really interesting in your paper was the way that you used the famous Brandeis, right to privacy article, Brandeis Warren, right to privacy article as sort of a framework for thinking about how we could kind of look at doctrinal history creatively to accommodate sort of harms that we hadn't previously considered within that framework. And I was wondering if you could talk about like why you thought that approach was helpful and how you think it works in this context.
Yeah. So first I'll make fun of myself because there's no more humble thing to do in your introduction than analogize yourself to Brandeis and Warren, right? So I was a little horrified by that even when I did it. So everyone's interested and always has been in sort of the foundational right to privacy article. I'm also interested in the paper in William Prosser's work on intentional infliction of emotional distress, and some of his other papers relating to privacy, and how I see these tort theorists kind of combing through common and statutory law to look for what is the interest that we're really protecting here. And I think what both, or I should say all three, Brandeis, Warren, and Prosser do is they really nicely look across doctrine and find support for the fact that courts are jamming in uncomfortably their sort of reasoning about rights into other frameworks because of the formalism of law. So they're stuck in these old categories. They recognize there should be a change, or that it would be appropriate to award a property interest or a privacy-like interest to someone, but they're doing it within the strictures of a law that isn't evolving. And in all cases, they sort of say that tort law should recognize this right explicitly and come to protect it, because that's going to bring more coherence to these areas of law, privacy, in the case of intentional infliction of emotional distress, to tort law more broadly. And so I sort of saw myself as being interested in doing the same thing, which is looking across doctrine. So not just at property cases, but at tort cases, and also at statutes, so criminal law statutes. I looked at graffiti statutes, and then also First Amendment cases talking about communications from property, and kind of cobbling together things by looking at them not within the formal structures of, oh, this came from the property silo, so it's a property case, or this is really a case about torts, a different tort, let's say, defamation or something. Instead, looking across for commonalities about communicating with and through property, and then thinking about what those interests and harms look like when you look at it differently, not within kind of the formal silos that law, I think being a law professor, sometimes forces us into. And then once you're kind of freed from the strictures of your silo and can see that there's recognition for communicative interests of owners across a bunch of different areas of law, it becomes much more easy to say you can and should protect that interest, and the law should grow to evolve to protect that interest.
So maybe for listeners who aren't lawyers or law students and maybe haven't had a property class, you could talk in a little bit more detail about the sort of dialectic, as it were, that you talk about between trespass and nuisance, and sort of how they worked historically and why it is that courts have found it difficult to kind of operationalize those doctrinal principles in the context of projection. And I think maybe specifically with reference to your use of the concept of appropriation, I think would be helpful for people to understand, sort of the general through line of your thinking.
Yeah. So I'll mention sort of a bit about kind of the difference between trespass and nuisance and why it might matter a bit. So the most important thing I think about trespass is to know that it's strict liability. So it's sort of a strict binary in the law. You either have trespassed or you haven't. And we really strongly protect the owner's right to exclude with that right. Nuisance is a bit more symmetrical. We recognize that two owners maybe, or two different groups of people both have rights to use or do the thing they're doing, but we need to kind of reconcile those rights. And so that's led to kind of more ad hoc questions. The test for whether something is a nuisance under the restatement of torts, which is really influential in developing state law on the subject, suggests that a nuisance is something that's substantial and unreasonable. And so unreasonable means kind of factually courts examine the surrounding circumstances and often will look at the harm to the owner balanced against the utility of the other owner's conduct, usually the more offending owner, the person who's the defendant in the suit. And so they do a little bit more kind of ad hoc analysis. So in my paper, I come out that we should be more in the nuisance category when we think about projection. For one thing, because of this strict liability feature. So I want to be careful that we don't allow property owners to stand too strongly on their rights. And the example of, I think I talk about in the paper, kind of a set of stray headlights or something, or I'm looking for my lost dog and I shine a flashlight on your house. We don't want people to be liable for those kinds of things. But I think we do want them to be liable for transformative communicative uses of your property. And the analogy to appropriation, appropriation is kind of an interesting term. It comes out of property. It was, I think, in more common use a while back as sort of, an unconsented taking of your property, often personal property. Now appropriation, we often think of as being more about identity. So it's used a lot in right of publicity cases, for example, that you've appropriated my identity to sell your product or something like that. And I really thought appropriation was the right word for thinking about what happens when someone communicates on your property without your consent. that it's both the loss of control, so like a taking or an unconsented use of something that belongs to you, but it's also appropriation of identity, because property and buildings are associated with their owners. And so just like the use of your name or likeness to sell something might be personally offensive to you or it harms a dignitary interest, the unconsented use of your building, I think, causes similar types of harms. It has the same type of feeling. So I think that nuisance allows us to kind of flexibly examine whether an appropriation has occurred. And so I kind of like it within the nuisance framework for that reason.
Yeah, I really like that way of thinking about the problem, but I'll also say that, like, as someone with an art background, when I hear appropriation, I don't necessarily immediately think privacy so much as I think about like appropriation art and the kind of ways that ownership and attribution are problematized, I guess, for expressive purposes in the art world. And you talk about kind of First Amendment tensions in your paper as well. I wonder if you could reflect on some of those for a moment in the context of both the cases that you describe in the paper and also other potential projection situations, like, say, for example, rather than it being a union sort of objecting to a property owner's failure to or refusal to compromise, what if it were like an artist or a political group making a point?
Yeah. So first, I mean, I love the analogy to kind of the art world, because I do think one of the things that's kind of fun to think about is property. Should we think of it as a form of self-authorship? I think often property theorists think that's sort of inherent, or should we think of it as not being as significant as your own sort of self-expression through art? This is something I think has been fun for me to reflect on. I don't know that I have a great sort of answer to that question yet. I mean, I think it's been fun to think about how people construct their identities and how they engage in self-authorship through the ways that they express themselves aesthetically on property and through their buildings. Obviously, there are limits on that. We can talk more about that, but I think that's a really cool analogy to think about. With the First Amendment piece, the First Amendment, as I mentioned, has already been invoked by one court as sort of a utility, a good thing about projection that should be balanced against the negligible economic harm to the property owner. And I find that sort of problematic as a matter of thinking in tort law, just because that sort of sets owners up on different scales. So if your harm is only cognizable when it's economic, but the benefits of the other owner's use will consider anything and everything, that sort of seems stacked against a plaintiff owner trying to stop the analysis. That said, I do think there may be a space for the First Amendment as a kind of defense to potential tort action. This is sort of a thorny area because there's often questions about whether a state's resolution of a nuisance action should really be considered the type of state action that triggers First Amendment scrutiny. But assuming that it actually is state action for a court to decide a nuisance case in favor of one party as against the speech of another, there are a few things to consider. So I do think that there may be sort of categories of speech, like you mentioned, that might be significant. So I think we often think of commercial speech as being less worthy of protection. So maybe advertising projections, of which there are tons and tons of emerging guerrilla advertising companies doing these types of like projections. Those might be especially in peril under my framework vis-a-vis the other types of projections that you mentioned. I also think there's interesting underlying state law considerations. So we know that some states, examples often are California and New Jersey, sometimes have a less strong property right or balance the property right against sort of public interests in a way that is unique to state law. And that's been significant in some of the cases about whether the First Amendment should entitle people actual physical access to other people's properties. So those underlying state law considerations about how strong the property right really is. The really strong analogy here here is to the cases about malls. So these are the sort of free speech easements, whether pamphleteers often or protesters needed to be admitted to private mall spaces. Probably the most famous case here is this case called Pruneyard versus Robbins, where pamphleteers were seeking access to a private mall. And because underlying California laws sort of permitted that access, the Supreme Court not only upheld the access, but also said it wasn't a taking for them to have to suffer that kind of physical invasion. So underlying state law considerations might be really important in thinking about third-party access to private property. That said, and I think this relates to your question about sort of self-authorship, I do think there's considerations on the other side here. So while we might say there should be some entitlement or some flexibility for maybe some kind of entitlements, maybe dependent on underlying state law, the other side's interests, in this case, the property owner's interests, look a bit like what we think of as compelled speech interests or interests against compelled speech. That is, there's a risk of misattribution if you are forced to have my message on your building. There's a risk of unwanted association. So I'm sure each of us can think of something that we would find really objectionable on our properties, whether it's something we politically disagree with or would just find offensive or upsetting or personally sad. And so I think that that the fact that there's interests on both sides here mean that there is a strong interest in sort of speech and political speech, but there's also an interest in preventing compulsion that relates to just the autonomy interest that people have in both their property ownership and in their speech interests.
Yeah, no, that makes a lot of sense to me. And I gotta say, I mean, there was something about the perspective of your paper, and I don't know if this is just kind of proximity, but, you know, it reminded me of James Stern's paper that I read and talked to him about last week, where he sort of questioned the idea of non-rivalry in the context of intellectual property goods or information goods. And it struck me that there was sort of this background concern in your paper around sort of a sense in which there's an assumption that these projection uses are effectively non-rival uses because they don't cause economic harm, and yet they do cause like hedonic harms in the sense that the property owners don't like it. And, you know, should we care about that kind of harm?
Right. I think that's exactly right. And, you know, I think James's paper, if I remember correctly, also relates to sort of a privacy interest in being able to refuse to allow your property to be used. And I do think that Light actually raises really interesting problems of rivalrousness in sort of both the novel sense and in the old traditional sense, because even though it's true that you can add more light to a surface, in this case, that will actually obstruct the message. And there's a really cool example. It doesn't come from the US, it comes from Australia, where protesters were upset that the Sydney Opera House had basically been sold as a billboard, that they were going to permit advertising on that iconic opera house. And so they went out with flashlights and in some case industrial projectors, you know, thousands of people, I think, organized a kind of grassroots effort, and they were able really to blot out some of the ad, particularly where it used white light. And so, you know, adding more light really restricts potentially the owner's ability to communicate from their own property if that's something they want to do. And this is something we know that some owners do want to do. I mean, I think as an art person, you may know that there's amazing projection mapping happening with consent, where there's amazing light shows and other displays being put on properties sort of around the country, certainly, and around the globe. And so I think that there are owners who are excited about this medium and, you know, will be excited to participate in it. And I'm more worried about the ones who don't want to participate in it and who would object to what would be put on their buildings.
Yeah. And, you know, one of the things that struck me as well in relation to the points you're making about sort of the tension between property ownership and the First Amendment in relation to these projections was like almost like a kind of, I think it was Cohen v. California, you know, like sort of sometimes the context and the circumstances are essential to the meaning of the speech. And I wonder if there are circumstances where like property rights to object to projections might be limited or potentially cabined by the need of the speaker to make the projection speech in a particular context and in a particular way, and like how to sort of reconcile those two values.
Yeah. So, I mean, this is, I think, something that's sort of lurking is if the speech has a particular nexus to the building or its occupant, then maybe this is an especially strong case for an entitlement to speak. We'll say that sort of the free speech easement cases have not treated this as super significant, that you don't always get to speak from the best spot if it's the facade, particularly because, the context of being in the proximity of the building may be close to as good, or at least a reasonable alternative to being on the building itself. And because being on the building, I think, does raise the kind of fun, if you're more of a guerrilla projection enthusiast, of causing unwanted association for the owner. I do think that maybe the owner's rights are stronger there, at least as against sort of the reasonable alternatives that are available. Although I do think, this is why that they're using facades, is because it does kind of carry this extra meaning or shock value. I will say that, again, not just the First Amendment, but other areas of law have been really hostile to the idea that you're entitled to specific spaces. So, alternatives in the First Amendment context, but I'm by nature a taking scholar. And one of my favorite cases to teach is this case, Loretto, which is about the entitlement, essentially a regulation that entitled a third party to install a cable, a really tiny cable down the front of a building. And it was sort of, this case that establishes that a de minimis physical invasion of your property can constitute a taking, even if it's a little tiny cable running down the front. And that decision has been criticized, certainly, but one of the interesting things to think about in that case is that they have to deal with a problem, which is that there's this regulation requiring the cable, but there's also regulations requiring property owners to have all sorts of other things like smoke detectors and mailboxes. And so there was this issue, how do we distinguish between these two things? Regulations require property owners to do things. And again, in that kind of self-authorship vein, the court treats as significant the fact that when you're required to have a mailbox or a smoke detector, you can kind of choose. You have some control over how to fulfill that obligation. Whereas if you have to run the cable down a particular piece of the building, you've lost your control over that space, however minimal. And so I think, again, the recognition that that the owner should have some entitlement to control what happens within the boundaries of the property is not just in First Amendment law, but is also running throughout lots of other areas of property law.
Indeed. I mean, it really seems to me like it highlights the way in which autonomy and the autonomy of ownership is so central to the way we think about property, its justification, and how we should think about interpreting property doctrine.
Mm-hmm. Yeah, and I think that, owners' autonomy is limited in all sorts of important and good ways, right? So there's lots of regulation that limits owners. There's lots of, judicial decisions in the nuisance context, for example, that limit your autonomy to do exactly whatever you want with the thing. But this is new and interesting because it actually entitles a private person to do something with your property in ways that the law isn't currently addressing, and that's communicating from it. And so, when we think about legislation, maybe there's capacity for your voice to be used and sort of changing the rules, or for electing a government that restricts you in the ways you find acceptable and you want others to be restricted. With judges, it's mediated at least through process. The problem, I think, here is that this is a private group sort of being able to do this privately outside the system without kind of room for fine-grained considerations of these competing interests. And so I think that's something else that's really attracted me to this project.
So Molly, I mean, your paper is specifically about projections in the context of property, but it struck me that in a broader way, it's really about sort of how we think about the nature of property ownership and sort of what the appropriate and legitimate rights of property owners are. And I was wondering if you could reflect for a moment on sort of what lessons, if any, you think the paper might have for kind of thinking about property law more generally.
Yeah, one of the things I'm really fascinated with, I think, and this is starting to emerge across my work is kind of an interest in this. We've been talking about it as self-authorship or privacy, but an interest in how property protects those interests and whether the law protects them enough as they're expected or as they're expressed through real and personal property ownership. I've written elsewhere about the Fourth Amendment, which is another context in which the ascendance of privacy hasn't always been matched by ongoing protection for property. And I don't think it's caused decreased protection for property, but has maybe caused interesting consequences. I've written specifically about personal property, where the rise of privacy has actually caused somewhat less protection for things like coats on the chair in Starbucks, where now you have no privacy expectation potentially, but you may still have property expectations. And so this interface between privacy and property, and sort of whether property law should more aggressively recognize and protect the privacy and dignitary interests involved in ownership, that's definitely one thing that I think my work is driving toward. I think the other thing that I'm really interested in, as we think about the nature of property ownership, is the right to use. So we think of the big three property rights as kind of the right to exclude, which gets a lot of play, the right to transfer, which we can also imagine is the right to, pass your property through your will or something like that. That also gets a good amount of play, and that sort of everyone who's been through first-year property knows that property hates restraints on alienation and all that sort of black letter stuff. But the right to use, I think, is kind of under-theorized because it's hard. It involves a lot of this symmetrical balancing of competing rights. And so it's kind of been intractable. I mean, everyone who teaches torts or property knows that nuisance is often called a legal garbage can. And I'm really interested in kind of thinking more systematically about the right to use, both in a private law context, so sort of nuisance, owner against owner, but also in how the state can restrict your right to use, which I think is part of my takings work. And I'm interested too in kind of how the right to use has been used nefariously kind of throughout property history. I mean, I've been interested really recently in some of Carol Rose and Rick Brooks's work on racially restrictive covenants, and how there was an interesting response to racially restrictive covenants, which was the creation of corporations that were owned by African Americans. And so there was this problem. So how do we treat a corporation that owns property? Do we assign it a race? What happens? And courts got around the problem by essentially looking at the feeble nature of the right to use. So they said, we're not going to assign a race to the corporation, but we're going to really restrict your ability to use it. So you may be able to own it as a corporation, but we're not going to allow African Americans to use the property. And so I think we really need to think about the limitations on the right to use and develop kind of better theories of that right and how we should be reconciling it with both the power of the state and as against other private owners.
Great. Well, Molly, thanks so much for talking to me today. I really enjoyed your paper, and I hope listeners will check it out.
Thank you so much. This has been a lot of fun.
Since I became governor, we've tripled aid to cities and towns, and that aid has helped keep property taxes from soaring right out of sight. Bad as they are now, they'd be much worse without us. In Boston, for instance, which was able to hold the line, the rate would have increased by $11 this year alone. In Worcester, $5. In New Bedford, $6, if it weren't for this new state aid.